this computer. Okay. All right. Let's go back to our script here. All right. Just to help me with reporting to the IEEE in the chat, would you just type the name that you used to register and the word IEEE if you're an IEEE member? If you're not an IEEE member, just type guest, and that'll help me significantly on filling out our reporting. Okay, so our speaker this evening is Phil Crowley. He was the inside counsel at Johnson & Johnson. He's an attorney and legal counsel for life sciences, technology, artificial intelligence, IT at his firm, Crowley Law, LLC. He's a board of trustee for research and commercialization at Stevens Institute of Technology. Recently, he's become a director at the Benjamin Franklin Technology Partners that's supporting and facilitating new technology business formations. Please welcome our speaker. If you have questions, put them in the chat and I'll interrupt and ask him to answer them as we go along. Phil, please take it away.
Thank you, Jay. Can you see my slides?
Yes, I can. And then I'll keep people on mute. So if you find yourself muted, unmute yourself as needed. Thank you.
Technology. People are fascinated by it, but it's really worthless, you know. It's a mere laboratory curiosity. Unless a group, a team of people take it, shape it, develop it, bring it through many obstacles, and create products and services that serve thousands or millions of people. Those people are called technology entrepreneurs. And by attending this evening's presentation, you've indicated that you would like to learn a little bit more about the problems they face and how you might be able to increase the services that you provide to them by helping them understand some of the basic legal principles that impact startups and mid-sized technology firms as well. Good evening, I'm Phil Crowley, and I'm delighted to be here with you this evening. Jay didn't mention it, but I'm a former physicist, so I'm kind of a technology junkie, and I really appreciate the sorts of things that all of you do. And what my goal is for this evening is to demystify some of the legal concepts that come up in the context of starting up and running a technology business. And they are things that it seems to me you can help your clients understand. And by helping them understand those issues, show the value of having you work with them, not merely on a technical level, but also in terms of business strategy. I have one rule with respect to questions. I love to have them. I'd much rather have this be a conversation among us rather than a dry lecture presentation. And I'll try to give you some examples of situations in which the legal concepts come up and the impact that they can have on the business. So let's get started. I put together a list of the top 10 causes that I have found that lead to the failure of technology companies and rank them in the order that they have occurred to me. Number 10 on the list is the failure to lock up the technology. In the electronics area, where patenting may not, and I see somebody taking pictures of the slides, I will make these slides available to Jay as a PDF so that everybody will have them. So in some cases, let's start out with the academic area. The academic area, you have a professor who is so enamored of his technology, he wants to try to develop it. And you as the entrepreneur or one of your clients go in to see whether or not they could license this wonderful technology. And the academic, of course, is governed by the rule publish or perish. So they are really oriented towards disclosing information, not keeping information quiet, keeping it silent. And so what I have seen happen in some cases where some promising technology that might have been patentable has been put into a journal article or put into a poster session at a public scientific meeting, which puts it in the public domain, which makes it ineligible for patent protection outside the United States. Inside the United States, you have a 1-year grace period, so it's not completely done. But in this era, being able to patent things outside the United States is important. So that's the academic side. Let's go over to the commercial side. You're dealing with many companies where it's where trade secret is the way that they protect their intellectual property. Well, a trade secret can be protected if the company uses reasonable means to keep it private, and disclosing it without a written non-disclosure agreement can, in many cases, destroy the protection that's otherwise available to trade secret items. And trade secrets are incredibly important. A patent gives you the right to exclude others from using that technology for 20 years from the date of filing. But a trade secret, like the formula for Coca-Cola, can last for many, many years longer than that. So number one, having procedures in place to protect and keep confidential the private, proprietary, intellectual property to which the company has access or that it wants to purchase or license. In the case of universities, my clients frequently have options to obtain licenses that include responsibilities for not only keeping information private and not disclosing it, but also to provide an opportunity to disclose any potential future disclosure of information to give the company a reasonable period of time. And usually that's 60 days to file a provisional patent application, because once a provisional patent application is in place, the disclosure of the intellectual property is protected. So that's locking up the intellectual property, problem number 10. But an issue that's even a little bit more important than that is the failure to conduct the business in a limited liability entity. It's like having a castle. The castle, you can see, has taken a lot of abuse and holes, but the people inside are safe. And so that's what a limited liability entity does for you. It's a limited liability company in order to get started, and a corporation at some point in the future. It is important to realize there are certain rules of the road that need to be adhered to. For one, entering into any commercial agreement in the name of the legal entity, not in your personal name. And this is certainly something that I'm sure most or all of you do in your consulting businesses. You have a limited liability company or corporation that enters into contracts with your clients, and it's not you personally, so that if something goes wrong, they get the assets in the limited liability company or the corporation. They don't get your car, your bank account, the college fund for your grandchildren or kids. So that's kind of basic 101, but it requires effort to make sure that you handle that properly. Item number 8 deals with the appropriate assignment to the business of all of the intellectual property that the founders have that's relevant to the business. I've had cases where founders have retained ownership of some of the intellectual property, some particularly in some of the patents that are key to the technology of the business. When investors come in to do their due diligence, they quickly realize that the company doesn't have all of the intellectual property they need to succeed, and so have to deal with that. It leaves a bad taste in the mouth of the investors because they're thinking, well, if the company has slipped up on this crucial element, what else is there that I don't know about? One item that occurs to me that I did want to mention back here in the choosing a legal entity. Startups find typically that investors are most comfortable investing in a corporation, even though the limited liability company is very flexible. And that flexibility is good for starters, but at some point, investors will want to know that they have a long history of corporate law that deals with the rights and benefits and obligations of stockholders, as opposed to members in a limited liability company. So as soon as a client has the opportunity to switch to a corporate form, if they intend to attract outside investors, that's a good idea. So we spoke about the assignment to the entity by the founders of intellectual property. Well, that inheres even more. I mean, it's even more important when you talk about employees and consultants, and of course that includes all of you. Because some of the great value in startups and technology companies generally is creating more intellectual property. It's the fuel that makes the business go. And so having written agreements in place with employees to ensure that everything that they create within the scope of their business belongs to the company. I know there are specific limitations on the ability to deal with that in California and in some other states, but in general, intellectual property that is created within the scope of the business and using the resources of the company can belong to the company. But it's important to have written agreements so that employees are on notice of that, and in the event that they need to be enforced, it's much easier to enforce that. But those written agreements are even more important for you consultants, particularly in the area of copyright protection. And that's relevant for software. There is a provision in the copyright law known as work for hire, and it is assumed that employees are creating copyrightable works, reports, software code for their businesses. But that is not the case with respect to third-party consultants. And I had a sad experience for one Johnson & Johnson company that had a beautiful, this is back in the days when we actually had physical brochures, had a beautiful brochure put together regarding their particular products, graphics, description, and after a year or so, it was getting out of date. They wanted to have it redone with all the beautiful pictures, and they got a quote from the company that had done the work, and the company gave them a quote that they thought was inordinately high, and they told the company, well, we'll just take this to somebody else if you don't reduce your price. And the company mentioned to them, well, you know, you never entered into a written agreement that gave you any rights in these, so we have the copyright on this material, and so you have just a license to use it. And if you want to make changes, which are called derivative works, you really have to have us do that. So it can happen in that area. It can happen to sophisticated companies, and it can happen to small startups. Case in point, you hire your brother-in-law to do some coding for this new iPhone app that is going to be a killer, going to create a lot of value. And then he goes off because he wants to do some other things, and you do a lot of work on it. Your company does a lot of work on it. It makes a killing in the marketplace. And your brother-in-law comes back and said, well, you're using some of my software, and it looks like you've changed it some way and created some derivative works, because he was talking to his lawyer to learn that lawyer speak stuff. What it means is amendments to the original software. And so I think you need a license from me for that. And so it puts the company in a very awkward position, because these things tend to come up when somebody sees that there's tremendous value having been created. And you saw that in the case of Mark Zuckerberg, when one of his roommates came back after he had been successful with Facebook to attempt to claim what he thought was his due. So having written agreements in place that deal with issues like this are tremendously helpful in avoiding disputes, and if the dispute can't be avoided, to providing the result that the company expects. Pizza. Everybody likes pizza. It shows us that having express ways of dividing up responsibilities and equity is important. First, the responsibilities, because in a startup, nobody can be responsible for everything, because if they are, they do not have a team, and that can be a problem. But in addition to having an express way of dividing up responsibilities, dividing up the equity is an important part of the discussion that the founders need to have when they put together the venture, because unless they view themselves as all equal partners with equal contributions to the venture, there may be some difference in the amount of equity that each obtains. And if you go out and look on the internet, you can find suggested amounts of equity that are given to various positions in biotech companies and other technology companies. And it varies by position. And typically the chief executive officer, who may not be the person who came to the company as the technology founder, gets a lion's share of equity, because the success of the venture, the commercial success of the venture, is on his or her shoulders. But there's another hidden issue here, and that is one of vesting. Do the people get all of their equity and all the rights in the equity right up front? Here's kind of an allegory of a case that sometimes happens. You have four friends: Alex Abel, Betty Barnes, Charlie Chadwick, and David Dominguez. And they come together, they're postdocs, they've got a tremendous technology, they want to take it forward. So they've got a license from their institution, and they are working hard at it. Well, 6 months later, Alex Abel gets an opportunity to become a professor with tenure at some prestigious college or university. So his three friends realize that this is an opportunity Alex can't pass up. Well, then 6 months later, Betty Barnes decides that she wants to take a different direction for her life and study other sorts of things. So she waves goodbye to the team. So that leaves Charles and David. Well, about a year into this, a year further into this, Charles is working so hard, he's having a nervous breakdown. So he tells David, well, look, I got to leave. I'm going to an ashram in Thailand to find myself. So he's gone. And David is there, and he's working 15 hours a day. In fact, he's spending so much time in the office that even his dog deserts him. And he puts in a lot of time and discovers some unique technologies that Alex and Betty and Charles weren't able to contribute. And as a result of that, after another year of hard work, he's able to sell the company to big tech for $10 million. Now, if you were David, I want you to think, how much of that $10 million do you think you should be entitled to? Is it, remember, you put in all the work after everybody left, you came up with some brilliant technical insights, and you made the deal happen. Is it $7 million? Is it $8 million? Is it $9 million? Well, under the deal that David agreed to, he's entitled to $2.5 million because everybody agreed it was the Four Musketeers. Everybody gets an equal share, and there wasn't any vesting. So vesting is an incredibly important element of appropriate distribution of equity, whether it's via grants of equity or via stock options. Number 5, the lack of having a team. Think of this in your mind's eye. You have just invested $2.5 million in a tremendous company, the tremendous technology that is operated solely by a Nobel laureate physicist. And you are beside yourself with the opportunity to get into this, and you shake hands with the professor. He's in your office. He goes outside. He's crossing the street. He gets hit by a bus. Where did your $2.5 million go? That is one of the issues that investors concern themselves about with respect to companies that are run by a single person. In addition, it's clear that in a technology business, it takes more than one type of expertise, and I'm thinking in particular in the life sciences, to be successful, because the businesses are so complex, the issues are so difficult to deal with, and multifarious. They involve multiple disciplines and multiple skills. So the lack of having a team to deal with that can be very harmful to the success of a company, because it interferes with their ability to get the fuel they need, which is money from investors, or if they're lucky, it can be from government grants under SBIR, Small Business Innovative Research Grants, or the like. An item that is even more important than that, though, is giving away too much to initial investors. And I know that certain agreements have come to the fore. The SAFE that was popularized by the Y Combinator, and the KISS convertible note popularized by 500 startups, and even convertible notes. But it's very important to assess the long-term effects of the money that comes in, because if the terms are too favorable, then there's a great risk that the founders and the initial employees who are really driving the business will be unable to benefit substantially from the work that they're doing in order to create a valuable business. That brings us to number 3, which is the failure to put together a written business plan. And now I know, and we all know, that every business plan is wrong. It doesn't work, it's not true, but it is the business planning process itself that forces entrepreneurs to look at all of the aspects of their business in a critical way that doesn't happen unless they're forced to write things down. Even if it's wrong, a bad plan is better than no plan. The next one is kind of self-serving, and I originally had this lower on the list, but I talked to my venture capital friends and they said, no, you can put this as number 2. And that is the lack of an experienced business lawyer to guide the business. We've just been through a number of items that have indicated landmines that a company can step on if they're not well advised. And the experienced business lawyer can help companies anticipate problems and put in place the kind of agreements and plans that they need in order to protect their interest and the valuable technology that they're creating. And the number 1 reason for the failure of technology startups has 3 parts. Let me start with the least important of the 3, although this is the 3. It is the failure of management of the company to devote its time, resources, and management attention to the 1 or 2 near-term opportunities, which will prove the proof of concept and or get the company to the next financing opportunity. Number 2 is even more important than that. It is the failure of the management of the company to devote their resources and management time to the 1 or 2 near-term opportunities that will provide a proof of concept or get them to the next financing opportunity. And number 1, which is the most important element of this particular item, is the failure of management to focus the resources and management attention of the company on the 1 or 2 most important ideas, projects that will provide a proof of concept or get them to the next logical financing point. So just like in real estate, the value of real estate depends on 3 things: location, location, and location. For technology companies, it's focus, 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 because in this world, small companies and increasingly large companies are constrained in terms of the assets that they can or are willing to devote to a particular technology project. And it is the discipline to focus those resources that frequently, most frequently, leads to failure because of the inability to show the basic viability of the project or business. So what I've done is I've kind of created a compendium, a free ebook that you can get if you go out to my website that discusses these 10 features and what companies can do to lessen the prospect that they'll fall into those traps and see what they can do in order to remedy them. So with that, I'd like to open the floor up to any questions or discussions, because as I said, I enjoy having this be a conversation as well.
Kim, would you like to ask your question from the chat?
Sure. Let me, I'm unmuted now, right?
Yes, you are. We can hear
Yeah.
you loud and clear.
Great. Yeah, very interesting aspects that you presented. Several of them I certainly had not thought about before. Your story about J&J wanting to update their very pretty brochure and the printer, basically leveraging them with saying that they held the copyright to it. How did that one play out? That took some real guts, I would say, on the part of a printer to try to pull that. Is that really one that will work?
Well, they got the job for the revisions, Kim, but that was the last job they got. And the people who were responsible for creating those brochures learned about contacting the J&J Law Department to get a form of vendor agreement that provided for transfer of all intellectual property rights to the purchaser. And that's something that, you know, all of you might consider in terms of, I am relatively certain you all have written agreements that you use to enter into arrangements with your clients. And in many cases, for larger companies, they have their own agreements that typically cover these sorts of things. But for your smaller clients, where they want to do things on a purchase order or something, you might volunteer a simple vendor agreement that provides them these protections to educate them and show them that you are a straight up player and want to ensure that you know, they get the benefits of all of the intellectual property you're providing, and that whether or not they've done that with other of their vendors to try to help them see whether or not they're going down a pathway which ultimately will provide some very serious repercussions.
Yeah, and one follow-up there. I can certainly see it from that side, and the potential need to have something that protects your IP. Let's say for my own consulting business, I'm printing my brochure. You know, do I need to have copyright all over it and everything, and get the copy center to sign off on the validity of my copyright before they reproduce it? That sounds a little over the top for me.
No, that's not what's required. I mean, they're just a copy center, but it's the person who does the creative work. So if you have some graphic artist working on that, I would certainly consider having in place some type of written agreement that makes it clear that whatever they're providing you is yours, and you know, some other things that I typically put in my clients' agreements. And I have to stress, I'm not giving legal advice here. What I'm
Sure.
trying to do is alert you to issues that can get in the way of a successful business.
No, they're good. They're good warnings, good cautions. Certainly something I hadn't thought about before. So thank you.
My pleasure, Kim.
Phil, could you expand a little bit? I don't quite follow the distinction between copyright as yourself as a company and copyright as being a consultant for a company. It sounded like there was two different rules there. Could you elaborate on the difference?
Sure, Jay. If one is an employee of a company, it is presumed that whatever copyrightable work you make, and a copyrightable work is something that's fixed and involves some type of talent to create. It can be a report, it can be a graphic, it can be software, and all it has to be is be fixed in some medium. If you're an employee, the law in the United States presumes that you have done that as part of your duties as an employee. However, if you are not an employee, the law presumes that the author of the work is the owner of the copyright in the work, unless they transfer it by some written agreement.
Okay.
So that's why there are different rules for
I see.
employees and for third-party consultants. But I think it's still a good practice to have in place a written employee agreement that provides for the ownership of intellectual property, so that if there is a question that arises, and we've all seen the newspaper reports about companies suing other companies for the theft of intellectual property when one employee leaves to go to another place, it's useful to have a written agreement in place that you can rely on, rather than having your lawyer says, well, the law says this, and kind of leaving it more in the discretion of the court in terms of how that will be enforced, rather than when you're employing someone to have in place appropriate intellectual property ownership and transfer agreements that protect the company.
Okay, I have had I have what is called a consulting services agreement with a client, and that client will have me work for his client. Generally, I don't know what the agreement is between my client and his client, but I have a contract with my client. And I guess the question is, generally I put in some description of what the project is, so that when I'm doing I don't know, project A on some topic, let's just pick wireless maybe, that I can assign everything to him. And then when I go to the other project and I'm doing something on, I don't know, fiber optic communications, say that whatever I do work, I do for that.
Right.
So what I find difficult is making the definition of what I do for them specific enough so that I can do work for multiple clients. Do you have any advice on how to think about that?
I think I'd have to go back to item number 2, is to hire an experienced business lawyer, because that one requires a good deal of factual analysis, Jay.
Oh.
And in terms of crafting descriptions for the projects, crafting descriptions for information that you may get from your client, protecting your know-how. I mean, you know things independent of the information that is brought to you by a client, and that background intellectual property needs to be protected as well.
Okay.
Because you don't want somebody alleging that because you worked for them, you are joint inventors, and now you have a patent, or they have the right to file a patent application, which could then prevent you from using your technology.
Yeah. Oh, that's right. Yeah, I didn't think of that. Yeah.
Because, I mean, just to be clear, sometimes technology, people who are brilliant technologists don't understand the niceties of patent law. Patent law does not permit you to make, market, manufacture, import, export, and sell your product. It allows you to prevent others from doing that. And here's a simple-minded example that helped me understand it. Suppose that Jay has a patent on bicycle wheels. And I come along and I say, boy, those spokes are really inefficient. I'm going to get a patent on a brand new type of bicycle spoke. So the question is, can I manufacture bicycle wheels with my new spoke? Because I've got a patent on the spoke. And the answer to that question is no, because J has a controlling patent on the bicycle wheel. And then the other question is, well, can J manufacture bicycle wheels with my improved spoke? Because he's got a patent on bicycle wheels. The answer to that is also no, because he needs my permission or license in order to do that. And so for us to be able to create bicycle wheels with the improved spokes, we have to license our patents to each other. So that's why you may hear among some of your clients doing a freedom to operate analysis.
I've heard
And
that
this is
before.
particularly important in the life sciences, because just because you come up with something doesn't mean that it doesn't depend on another technology or might infringe another patent. And initially, startups don't have much money to do a detailed freedom to operate analysis, but at some point in the investment period, they will have to do that for most sophisticated investors, so that the investor can be certain that the company will be able to manufacture and sell the product that is subject to its patent.
Okay, thank you. Brian, you have your hand up. Would you like to ask a question?
Yeah, can you hear me all right?
Yes, we
Yes,
can.
coming through loud and clear, Brian.
Great, thanks. Hey, thanks, Phil, for the talking. It was really fascinating. I still I want to look at the stuff afterwards and kind of go through it again and dissect a little more. But one thing I was curious about in this, and something that I've encountered that I'm not sure if it's overly stringent or not, which is so first of all, I should say I'm a single person LLC, right?
Right.
So I am my company, and I'm a services consultant, and so my clients all usually have the usual consulting agreement, and with theirs, and say recently a particular client had one that of course was very very medieval in terms of assigning all IP and ownership of anything that comes out of it to them, right? And so
Yes.
but okay, fine, but then in addition, right, they want me to do an invention assignment agreement, right? Which between basically myself and myself, right? Because I mean, the consulting agreement will be with my company, Power Rocks LLC,
Right.
right? Usually, if they try and do it to me directly, I change it to I want it to be to my company. But then they had me do
Good man,
the
Brian.
assignment agreement between. Thank you. But they had me do the assignment agreement between myself and between Brian and Power Rocks, and which again basically repeats all the stuff and all in there. So is that actually? I mean, I assume it's legit, but does it actually serve any purpose or anything, or can I tell them that this is pointless and you already have all of this you own through from everything that services that Power Rocks provides, and it even says of all its officers, employees, all the usual stuff. So why would I need this additional assignment agreement between Brian and Power Rocks if Power Rocks has already done that in the consulting agreement?
Right. I mean, without looking at the agreements, I can't really tell, Brian, but I can say that if the agreement with your company is so comprehensive, I mean, you might just push back and say, this is already covered in what is in here that is not covered in my agreement with my LLC. And if it's not in there, put it in there.
Well, I guess the argument was it's not that's between us and the LLC, where we want all employees to pledge an oath of allegiance or whatever. And I guess what I'm just wondering. I mean, I'm not asking for legal advice in terms. I understand you don't haven't seen it and all that, but I just meant in general. Is it kind of is that an atypical situation, especially for a single owner LLC, where they would want, that type of agreement and invention assignment for, the company as a whole providing the services, and then from individual employees, especially when it's only the whole company is one individual.
Yeah, I haven't seen that regularly used, Brian.
All right, fair enough. Oh, well, hey,
So
thanks again.
I think you
We're
can push
talking
back on that basis and say, this goes way beyond the pale. It's what
Okay,
I
good.
refer to technically as my way beyond the pale defense.
Fair enough. Well, I'll remember to play some Procol Harum for these guys next time I see them. All right. Thank you.
Hey Phil, this is Kevin Curran. I mean, one thing that might be an option is just to include, have all of those individuals as a party to a single agreement, so that they all are signing the same agreement, and so that you've got the legal entity, but then also the Brian as an employee or owner of the LLC, so that he's signing individually as well as he's signing corporately on behalf of his LLC, so that you don't have multiple documents, but you just have one agreement, and it covers all of the affected individuals or entities.
So that the idea that you're suggesting, Kevin, is to have Brian sign as an individual the same agreement that his LLC is signing, right?
Right, to name him as a party to the to the overarching agreement, so that he would be a party and his LLC would be a party, and each party, those two collectively would be, characterized maybe as the independent contractor, since we like to use sort of generic terminology and agreements, and that all affected independent contractors as a party to the agreement would then assign any intellectual property that's developed pursuant to the agreement. And so then that would encompass sort of both scenarios, which would then avoid the need for Brian to execute a separate agreement between him and his LLC that would assign the IP that he generates for his LLC to his LLC, so that his LLC can then transfer it from the LLC to the LLC's client.
How
Kevin,
would that affect Brian's liability perspective in terms of being an individual party to the commercial contract?
Well, so I mean, the challenge is that his LLC doesn't own the intellectual property outright, just in the same way that that any other employee, I mean, apart from the copyrights as a work made for hire, but any inventions that he creates for his LLC, he still continues to own individually. His LLC doesn't own them unless he, in writing transfers assignment to his LLC. Even though he owns those two things, he owns them separately. He owns his ownership interest in the LLC, and then he separately owns whatever inventions he creates.
But why is that even necessary, right? Because if the original agreement, like, most will say, so it's with the LLC, right? And it says, okay, anything the LLC does over the course of this work, this statement of work for this client, you own it. And it says, and that covers all, employees, officers, janitors, mailmen, whatever, third parties, whatever. So isn't that already done there? Isn't that just the end of it? So why would you need to individually also do it?
And so the LLC as a party to the agreement can only assign what it owns. And if it doesn't own the intellectual property generated by, the janitor, then even though it says it's assigning the intellectual property generated by the janitor, that's of no import because the LLC didn't own it to assign it.
I see. Even if the janitor generated the LLC over the course of doing the work for the client, specifically for that client, it still would be the janitor's. And even though he is employee of the LLC that pledged all the work related to this.
Wouldn't all the
Okay, I wanna
LLC
get that.
employees need an agreement that, you know, their work is owned by the LLC? Wouldn't that be what's required?
Right, that's what-
That would be a good practice for a company to have for employees. In this particular case, Brian is the sole member of the LLC. And so
Right.
with respect to that, it's difficult for me to see how a court would say that the absence of a written agreement between Brian and his LLC means that he didn't assign to the LLC everything that he had the LLC agree they were going to transfer to the
Right.
client.
But if
Now,
you had
theoretically,
employees,
employees are different.
and especially if you had really creative janitors working for him, then he really should have that agreement, it sounds like.
That's right. Anybody who touches any paper, even if they're taking out the trash.
Oh,
But well, so let's say in that case, let's say I got 10 of those guys. Even then, shouldn't I be able to say, well, the agreements between, you know, my employees and my company or whatever, the LLC, are frankly none of your business. If or are confidential. And again, going back to, you know, you've already committed that, you know, anything associated with anyone who works on this project for you, you already own it. Right. So it should be, I would say, whether, you know, if they say, well, what invention assignments has your employee signed with you? I would assume I should be able to say none of your damn business, and you're still covered.
I'd have to see the agreements, Brian.
Well, Brian, I would,
Well, anyways,
I would
it's been a
say
fun exercise.
you're exactly wrong. Unfortunately, Brian, you're exactly wrong. It's 180 degrees opposite of your answer. They do have
You're the Esquire.
yeah, they do have a very important interest in the agreements between your LLC and your employees. And every agreement between your LLC and your client, if your client has Phil reviewing the agreement, Phil's going to make sure that his client has a provision that requires your LLC to document all of your assignments from your employees to your LLC so that your LLC can then legally transfer ownership to his client. And if that chain of ownership, of custody, is broken, the transfer from your LLC to his client is virtually worthless.
I see. Interesting. All right. Well, thank you very much for all the input. Sorry, I didn't mean to rat hole.
No, it's
I thought maybe this is
question.
something everyone else
Yeah.
faces too.
Very interesting.
Brian, it's good to have a discussion of these things because you never know when they will come up for other people. And I think that it helps people understand that when you're dealing with intellectual property, you know, having well-drafted written agreements to deal with is a great protection because it answers many of these questions and obviates the need for things like independent inventor assignment agreements.
Yeah. Fair enough. Thanks, Ian. I think someone else or
Fred,
someone's got a hand up too.
Fred, you have a question? Want to ask your question? You're off mute, but we can't
If
hear
you're
you
talking,
yet.
you're on mute.
Do you have another mute button on your headphones? Oh, there you are.
Can't hear you.
Fred, we can't hear you. You seem to be muted.
If only we were lip readers, at least we'd be there.
No, we can't hear you.
If you've got, are you on a laptop?
Fred's question is in the chat. I can read it for you. It's regarding, let's see, I have a question regarding the business plan. Stanford and the federal government are pushing entrepreneurs not to publish a business plan and instead to use the business model canvas. What are what are you up to? What are you up to? It's producing a business plan.
Oh, I am agnostic about the process that people use to deal with planning their business. Canvas, at least what I know about it, is a means of developing an approach to your business and putting together a plan for how the business works and how it fits together. And so long as a company has an organized way of forcing themselves to go through the process, I think that is the idea. Whether you do it via Canvas or whether you do it through a traditional business plan, it's the exercise and discipline of having to face reality and come up with some answers that you can put down clearly and have tested by your business advisors, potential investors, and others. Otherwise, it's just a set of ideas running around in your head, and that risks missing dealing with some really important issues because you didn't think through how you're going to start and develop the business.
I
Hope
took
that helps, Fred.
I took the I took a business. I was for a potential client. I joined him on one of the Rutgers business model cohorts, I-Corp cohort. This is the National Science Foundation business accelerator for scientists. If you ever get a chance to take that course through Rutgers, it's fabulous, fantastic. And it's centered around the business model canvas, and I love the business model canvas, and it's great for finding your product market fit. I personally think that it is the driver for your ultimate business plan. Once you understand your customers and what your customer want and what you're going to make, that drives your business plan. So I don't think, me personally, I don't think they're mutually exclusive. I think they're a good combination is the traditional business plan that's driven by business model canvas. But I don't have a lot of experience doing that. So I'm open to more input and data on the subject. Fred, did that, let's see. Oh, he took it through Columbia and New York University. Oh, that's great. And you liked the Canvas course? Okay, so he took it and he enjoyed it. Do you feel that the business model canvas is sufficient for creating a business plan, or would you what additional items would you like to see in your? Okay, not really sufficient. Okay, so I think we agree. Yeah, that's great. George, did you have any questions?
No, it's fine. Thank you.
Okay. Harold, any questions?
I have a comment. Your number 2 point about lawyers, 100% correct. You know, I've got essentially 40 years experience, and I wish I knew good lawyers before. Right now, I know great lawyers, but I'm in Palo Alto, and I get people come up to me all the time, young people, say in their 30s, millennials, and I deal, because it took me a long time, I deal with Fenwick and West, and
it's a great firm. I know them.
And Wilson Sonsini and Cooley, because I worked with these people for 40 years, but they charge too much. Do you work with seed or Series A companies that if I have a bright guy who I meet at a cafe, and that's how we do it in Silicon Valley, great guy, I think he has good ideas, would you help someone in seed or Series A?
Yes, I'd be happy to talk to you about that, Harold.
I don't have anything now, but I'm just saying, I've looked at 1,000 business plans, 3 of them worked out. It doesn't have to work out perfectly, but you do have to have a plan. And so it's always plan B and C where you bail out. You don't go public because you need 150 million, but you can have a good company that's 50 million, $100 million, and you sell it to Intel, which I sold 2 years ago to Intel in 5G. So,
Right.
yeah. Okay, so I'll tell someone to get in touch with you, and it's Crowley Law.
Yes, sir. Thank you, Harold. I
You're quite welcome.
appreciate that.
It's all about networking.
Yeah, that's exactly it. But, our focus has been to, I've got 2 other very experienced lawyers who work with me, and we work in a virtual environment. And so our costs are low. And instead of having to feed a large cadre of junior associates who are kind of learning the business, you get people who have worked in businesses and understand how to separate the wheat from the chaff.
That's great. Thank you.
Howard, do you have any questions?
No, I thought this was a great presentation. I got stuff, but this is recorded. I don't like online because I've signed 3 NDAs and I have investments in different companies, and I don't want to say anything without, getting approval.
Sure.
That's a good question. NDAs, if I've signed NDAs, what if they don't have a date that ended? Is that invalid if the NDA did not have a specific date?
Generally, no, it's not invalid. Sorry to tell you that, Harold. I mean, if you get into, here's the problem of having inartfully drafted documents that don't figure out what the problems will be down the pipe. Then you leave it to the courts to decide what it means. And so it's important to have some sunset provisions on some things. On some matters, as you can appreciate, for example, trade secrets. Trade secrets retain their protectability and their value as long as they're trade secrets, but material that comes out in the public domain and even a patented material has a lifetime to it. So it's useful to have a lifetime for things other than trade secrets.
Okay, I appreciate that. But when you're a young engineer from the Michigan College of Mining and Technology in 1966, you don't learn these things.
Well, Harold, that's why we all believe life is an adventure.
Absolutely.
No, I don't, unfortunately, Harold, I don't think they teach these things really pretty much anywhere, apart from law school, or these sorts of presentations. Though I have a question for you, Phil, and this relates to Harold's comment about NDAs. When going back to locking down your intellectual property on point 10 at the beginning,
Right.
So, there's this contradiction or this sort of paradox of keeping things either protected through trade secrets or patent applications, and yet the tension with trying to get funding to ramp up and develop a prototype and develop enough technology that you can get further investment. And I see that as probably one of the biggest challenges because, you have patent applications that are being published after 18 months from filing.
Mhm.
And I'm wondering, there is a strategy, and I think it's somewhat risky, but I guess it's, it's the risk benefit analysis that is going to be very fact specific. Whether you see, companies, assuming that they don't file for a provisional patent right off the bat, but maybe wait, a couple months before they get their ducks in a row. And then they file a provisional patent, which is eventually followed up with a non-provisional, and that's scheduled then to publish 18 months later. Do you see, and now getting really to my question as sort of the lead up, do you see many cases where you're going to have a client that has technology that's readily reverse engineerable when the product hits the market or when, it's just, analyzed, that a company is going to maybe not initially claim the benefit of the first provisional and just basically let it go expired, or maybe file a first non-provisional to get the benefit, but then file a non-publication request and try to sort of push forward and maybe then file a continuation later on that does have a publication request, to delay into the future the publication and making the information available on the internet, versus still trying to claim an early date for invention for prior art purposes, and sort of the tension between that and getting some investment to really make the product fully developed.
Yeah, that's an interesting scenario, Kevin. I haven't encountered one that was quite so complex. I mean, in my experience, people are scurrying to get provisional patents in place to protect what they've discovered. And then with respect to dealing with outside third parties, those that where there's some question, for instance, Chinese entities, to just hold back the secret sauce as long as you can. Because some of the technology that accompanies the patent involves some trade secrets in terms of manufacturing technology or protein chemistry and those sorts of things, which are not under the law necessary to enable a person proficient in the art to produce the invention, which, as you know, is one of the requirements for a description in a patent. So it's a difficult question that is being handled differently by different companies, but it's definitely a challenge to balance the need for exclusive use of a technology and the requirement that if you disclose it in a patent application and don't get worldwide coverage, effective worldwide coverage, then there'll be somebody out there who will be reading through patents and figuring out how to make, use, and sell your invention in areas that don't particularly respect intellectual property rights. And so that's part of the calculus of figuring out what to do. And it goes back to the business decision is, where are your primary markets? Do you need to cover the entire earth in order to have a multi-billion-dollar potential market for your product? And if you have a multi-billion-dollar market for your product, isn't that enough to drive the economics? But it's a fascinating question, and I think that it's highly fact-specific, dealing not only with the technology, but the markets involved. I wish I could be clearer, but
maybe
the world is a fog.
That's a really good perspective so far. I mean, maybe something that a related question might be, what are the maturation periods or investment cycle durations that you're seeing? Are, in order to get a particular round of investment money, are you seeing, 3 to 4 months, 6 to 8 months, because that sort of has to overlay your patent filing strategy. So if it's going to take, say 12 to 16 months to get your initial funding, then you're barely going to get your first patent out the door before it gets published, before you get your first funding. But if you can get, rounds of funding every 3 months, then you've got a better chance maybe within that, before your patent gets published, to bring something, some sort of prototype to market to, before other people just jump in and start counterfeiting it.
Right. Now, you have described the conundrum of the presidents, but that's why they get more pieces of that pizza pie that I showed you in item number 6, because those are difficult questions to make. And again, you need a good patent lawyer, patent counsel, who's really market oriented to try to help you figure out what to do in situations like that. And again, very fact specific based on who the competitors are, who the potential competitors are, where your markets are, what is the strength of your patent. You know, after the Alice decision, Alice Industries decision by the Supreme Court, the viability of software patents was greatly called into question. So many companies, particularly the SaaS companies, said, well, okay, we don't have to patent things because we've got everything behind a graphical user interface, and none of our customers are going to see anything other than the output of the software. And so for us, you know, the question is, well, if I have a provisional patent, will that make me more attractive to potential sources of income? So that's a question. Even if you don't go forward and actually file the regular patent application.
So do you, I guess, is your experience that the startups are looking at least one round of funding, hopefully within the first 12 months? Beyond just their out of pocket, what they're putting in as their,
It has depended on the client. There's one kind of unique that, if you're in the life sciences space, Kevin, I mean, and you're skillful, and one of my clients is extraordinarily skillful at getting small business innovative research grants. And although the money is slow, it's completely non-dilutive. It's free money. All you have to do is produce a report that shows certain things. And if you can find a rabbi at the National Institutes of Health for whom your particular interest is exactly aligned with their interests, you can wind up getting substantial amounts of non-dilutive funding that way. More difficult, I think, outside of the life sciences. So I think those companies are more focused on proof of concept, prototypes, and that life cycle, and being able to do that. And then, there's the big valley of death. You get to the seed financing, and then you got to find a way to get to the next point of a point of proof or a point of financing. And it can be very difficult to sustain a company during that period of time. So I don't have a good solution for that, and I haven't seen anybody else who does.
Thank you.
Sharon, did you have a question? I hope I pronounced your name, Sharon. Bob? Hey, Bob, do you have a question? If you guys want to type, if you don't have microphones and you want to type them into the chat, I'll read them. Ben, do you have a question? And then Kim, I don't think you asked a question in this round. Do you have a question? Okay, so last chance. Anybody have a question? Okay, Fred, thanks for joining us. Tim, okay, Kim, thank you.
Well,
Anybody else
well,
have a
it's me, but-
question?
I want to say thanks a lot. It's nice to meet you guys. Thanks again, Phil, for the talk and the great discussion, and look forward to perhaps seeing some of your New Jersey folks in the near future.
And also, for those of you who participated in this presentation, if you go out to my website and see some material on which you have a question, please send me a request for information on the website. I'd be happy to talk to you about those things. No strings attached.
Okay, I'm gonna end the formal meeting and stop the recording, and we can sit around and network if you like. All right.